This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions all about car and truck wrecks. December is one of the most dangerous times to be on the road. If you've been in a wreck just recently or you're still suffering from an older wreck, tonight's the night to call in and ask your questions. You need to understand what your legal options are. Maybe the insurance company has taken their time about talking to you. Or maybe they are the exact opposite and they're pressuring you to accept some deal and you wonder, ooh, should I talk to a lawyer? Could a lawyer help? Call in your questions. The 31 Law Call number is 256-536-0077. You can also email your questions. You can email any legal question any day of the week. You send it to lawcall@waytv.com, and when we get to a show that's on point, we pull some out. We've got some of your questions about car and truck wrecks. Tonight, getting us started tonight, we've got Will League and William Meservey from Timberlake and League. They are personal injury attorneys, so they handle car and truck wrecks all the time, talking to the insurance company and negotiating with the insurance company to figure out what's fair, because I guarantee you they're not offering you what's fair straight up first time.
You know, Sharon, in the last 25 years of doing this, most of the cases that are litigated are motor vehicle wrecks, 18-wheeler wrecks, car wrecks, and most of the litigation surrounding that is involving an individual versus an insurance company. Now, how the case is designed, it's usually either William Meservey versus Sharon Doviet. The jury would not know, Sharon, that you have insurance.
Why would they not know?
It's by design. And so the insurance lobby got together and said, well, we don't think it's fair that the jury knows that the defendant driver has insurance. That may unfairly sway them. And on the other side, if let's say William Meservey has medical bills and his health insurance pays that, the jury is allowed to know about William's insurance, but they're not allowed to know about yours. And so it's unfortunate. But a lot of these cases are tried. We got circuit court, district court, the minimum of $50,000 in district court. And William, we look at these cases, and a lot of times we'll try them in circuit court with a jury. What's the difference in those, whether we file it with just a judge or a jury?
Yeah, so district court's going to be sort of an expedited process. You're not going to have all of the same discovery that you have in a circuit court case. So in a circuit court case where you may have depositions, you may go through interrogatories and requests for production of documents, all of that's going to be streamlined in the district court. In addition to that, in the district court, you're going to get what's called a bench trial, okay? And a bench trial is simply that the judge is going to be both the trier of the law and the trier of the fact. And if you're in circuit court, you get a jury trial, or you're at least entitled to a jury trial. You could have a bench trial as well. And typically, the situation there, if you're having a jury trial in circuit court, the judge is going to remain the trier of the law. And the jury is going to be the trier of the fact. They're going to determine what are the facts of this case, and does it warrant a recovery for either the plaintiff or for the defendant.
Let's give you tonight's You Make the Law Call video. So we pulled some video from YouTube. This is a situation, you see a lot of stories that are rear-end collisions. Well, this one's got a little bit of a twist. The SUV strikes this trailer seemingly for no reason. Now, we don't know whether the driver of the SUV just wasn't paying attention, they're on the phone, they're looking down or something. But did you notice that the trailer, what if the trailer doesn't have tail lights that are working? Now, we don't see any brake lights. But if that were part of it, does that make a difference? And does it make a difference in Alabama or other states?
It can. So looking at this video, it looks like it's daylight. The other vehicles don't have tail lights on. So it looks like the SUV just slammed in the back of them. Now maybe it's going slow, but again, you have a duty to make way for the vehicles in front of you. I think it's going to be the SUV's fault. Now, we've had this case. Now, if they'll say it's nighttime and there are no tail lights, well, that's contributory negligence. So let's say the trailer wanted to make a claim for the damages to the trailer.
Yeah.
There could be an argument that contributory negligence is at play in that the trailer driver failed to have his lights on, so therefore was in violation per se of any type of statute or rules of the road, and therefore he or she could not recover for his or her damages from the other driver. Now, that would be different if it was a comparative negligence state. So William and I, we do cases. Now, first of all, I didn't talk about William's red jacket. We have to we're festive up here. Thanks so much.
Yeah, we came prepared for Christmas.
So we try cases in Tennessee and Georgia as well.
Okay.
And so when you're talking about comparative negligence is one of the illustrations that I use. Let's say there's a four-way stop. and William comes up to the stop sign, and his wheels don't quite come to a stop. So technically he ran that stop sign. But Sharon, being the rule follower she is, she stops at the stop sign. Now, William comes through and hits her. Can he recover? Well, William technically violated the law, so under contributory negligence, he could not recover because he caused or contributed to that particular wreck.
In Alabama or
in Alabama?
Alabama.
Now, comparative negligence, and I think I messed up this scenario. William goes through just barely.
Okay.
You barrel through going 100 miles an hour.
Okay.
It's your fault.
Okay.
He kind of went through, but his wheels didn't
But he did
quite
a
stop.
little something
Little
wrong.
bit. So a little bit, that might get you off the hook.
In Alabama.
Because he was contrived. Now, in Georgia or Tennessee, comparative negligence takes over. And what that would say is, let's say William was 10% at fault and Sharon Dovey was 90% at fault. Then under that law, Sharon would be able, or William would be able to receive 90% of his damages. So it'd be a fair offset. And what people don't realize in Alabama is contributory negligence is very tough if you have any type of fault of your own. So it makes a difference. And so William, when we try these cases, defense attorneys are always trying to get that jury charge into evidence. And what's the,
It's
how can that
absolutely
affect your
right.
case?
And it helps to know exactly what contributory negligence is for those out there watching tonight. So it is actually a defense to negligence. And what the defense is arguing is that, look, the defendant was negligent, okay? But what we're saying is that the plaintiff contributed to the cause of the collision. And we're one of 4 states left in the union that has this old archaic law of contributory negligence. It is a complete bar against recovery from the other party. And so, like Will said, if you're 0.01% at fault, it can be a complete bar for recovery in the state of Alabama. If you're 0.01% at fault in Tennessee, you could recover 99.9% of the damages.
Seems crazy.
So it is a little bit harsh on the plaintiff. But again, that's the law in Alabama.
Sharon, we advise clients that when they come in, oftentimes the insurance companies will call them for a statement.
Yeah.
And they want to be helpful and they want to cooperate. Well, a lot of those insurance companies, the questions are designed. Were you running late? I know you're trying to get to volleyball practice, take the kids. And what time does practice start? Well, it was 6:30 and the wreck happened at 6:35. We're running late. Oh, you were in a hurry.
Oh,
all of a sudden they start setting you up to where you've now admitted that you might have been speeding, you were running late, or you were distracted, and that would trigger a contributory negligence defense.
And you can't back up from saying that, right? You gave
cannot.
a statement.
And it could be an innocent statement to where you're answering those questions, and now all of a sudden you've talked them into a defense where otherwise there wouldn't have been. And sadly, those statements are designed to defend the case.
Calling your questions, the 31 Law Call number 536-0077. We've got this email question from Paul. Paul wrote in, I wrecked while driving with my kids in my friend's car. It was or is insured. Airbags deployed. The car's totaled. The other driver is at fault and got cited. It was scary, but besides my finger being burned by the airbag and a few days of chest tightness, there was no long-term injury. My friend's insurance will handle the damage claim, right? Can I sue the faulty driver for the trauma caused to me and my kids? Okay, that's kind of long, but dealing with driving somebody else's car, are you covered? Is he covered?
Yeah, in all likelihood he is. So the situation here is going to be that there's 2 parts to this claim, okay? There's a property damage portion of the claim, and that's not going to belong to the gentleman or the children. That's going to belong to the owner of the vehicle.
Okay.
Okay. But as far as the bodily injury portion of the claim is concerned, assuming that the other driver's 100% at fault, the first insurance in line is going to be the liability policy of the other driver. Now, after that, when we get to uninsured, underinsured motorist coverage, it gets a little bit more confusing. That's first going to go with the uninsured, underinsured motorist coverage of the vehicle you were in. So that's going to be the friend's car. And then if they run through that, his own uninsured, underinsured motorist coverage is going to be applicable as a secondary UM coverage. And that's even though his vehicle's sitting in the driveway at home and not involved in the wreck at all.
Wow.
So
interesting.
It can get very complex with the different layers of coverage, but property damage claim belongs to the owner of the vehicle, bodily injury claims for each of the injured parties.
And with regard to the actual claims themselves, I think the final question was, could he have emotional damages for him and his children? You know, there's some case law that says that it has to tie to a physical injury. They mentioned there was some type of burn from the airbag. But in those cases, you want to make sure you have to prove damages. So in Alabama, you cannot testify that the proximate cause of your injury was the motor vehicle wreck. That has to come from a medical professional. So we need medical expert opinion on that particular issue, whether or not the injury. Now remember, negligence is like baking a cake. You got to have sugar, milk, flour, eggs. You have to have duty, breach, causation, and damages. So the causation and damages in this particular situation, you would have to show that you and your family members, the children, suffered some type of trauma. And whether that be through going to a doctor, going to a counselor, to have someone testify that yes, indeed, these particular injuries or damages were a proximate cause of the motor vehicle wreck, and you'll have to prove that sequela from the motor vehicle wreck to the emotional damages that you're claiming.
We got this question from Wendy. Wendy wrote in, what if I wasn't wearing my seatbelt at the time of my accident? Can I still recover damages? I realize I'm very lucky my injuries are not worse, but I do have some bruises and back problems now. So does not wearing your seatbelt, because that's the law, she's supposed to be wearing it, right? Does that keep her from being able to recover?
What do you think, William?
I don't think it's going to necessarily be a complete bar against recovery. Now, what it is going to do is it's going to cause some muddiness in the water, right? And, you know, you've got a duty to mitigate your own damages, and there's this contributory negligence as well. But, you know, they're going to argue that, that they should have had their seatbelt on, that the injuries would not have been as bad as they were had they been wearing their seatbelt. And so, you know, the duty to mitigate your own damages and to comply with the law is going to be an issue that's going to be brought up in that case, but it may not be a complete bar to recovery.
Let's talk a little bit about if you were driving a company vehicle, or you're out, you're on the job when something happens. Does that muddy the water too?
Well, we look at, okay, so workers' comp is a very poor body of law, but basically it's codified in that if you're injured during the line and scope of your duties for your employer, you're entitled to recover medical bills, time off from work, 2/3 of the time off from work, and if you have some type of impairment. It's a very poor body of law, but oftentimes we see cases where you're driving a company truck or company vehicle, you're in some type of wreck, you're injured. So you have two parallel claims. And the issue is, on the workers' comp side, can we get you back to, where you were in making money, making a gainful employment, and get you back on the job and see what's going on there. So there's other than those three benefits, you're not entitled to any. Now, under tort law, you have pain and suffering, medical bills, things like that you can recover. And then the question is, if you recover from the third-party carrier who caused the wreck, then the workers' compensation will get their money back.
Okay.
And so it's a big money swap. And so there's a timing of that. And oftentimes you're limited to what doctors you go to under workers' comp.
Okay.
And you have different goals. The goal is to get you back to work, as opposed, well, depending on the doctor, the specialist. Oftentimes we and I are fighting with the workers' compensation insurance carrier to approve a physician. And as Americans, we're used to having health care provided to us, and we can choose our doctors.
Yeah,
and all
I
these
want to choose
plans.
my doctor.
It's a whole different world when you get into workers' comp. And if you go outside of workers' comp, then they won't pay for it, and you're going to have issues moving forward.
Okay.
And so it's a very difficult law to navigate through to get your medical treatment and prove your damages, and that's why you need to sit down with a lawyer and see the best path forward for you and your family.
And one of the big things about those cases, a workers' comp case plus a third-party case, an auto accident, in the auto accident, you're entitled to pain and suffering and mental anguish. There is no pain and suffering or mental anguish in a workers' comp case, and it does create quite a large disparity. But the right of reimbursement that workers' comp has is not just going to be for the money they paid directly to you. It's going to include anything they paid out for your medical bills, and like Will said, anything they paid out for temporary total disability or the 2/3 your average weekly wage while the authorized treating physician has you out of work.
Okay. We're going to take a break. We'll be right back answering more of your questions about car and truck wrecks. Stay with us.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Doviet. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're talking about car and truck wrecks. We've got with us the Wills. We've got Will League and William Meservey, both from Timberlake and League. We're talking about car and truck wrecks, and this is something that you guys do all the time. But if people are watching Law Call and they're not in Madison County, if they're in DeKalb County, they're in Lauderdale County, do they need to hire a lawyer that's over there? Can they hire you?
Yeah, they absolutely can. And one of the good things that came out with COVID is everybody learned what Zoom was.
Yeah.
You know, and so we have virtual meetings with clients. Sometimes when we do nursing home cases, family members are in town from all over the country.
Yeah.
And it's hard for them to come into our office in Huntsville, and we will go to them as well. But sometimes, given the nature and circumstances, we can jump on a Zoom call with the family. And a lot of times it's better to explain to the family all together what's going on. Everyone, you know, they're oftentimes around their loved one. In this particular case, the judge was kind enough to let us do a Zoom hearing. And so basically that's me and my clients right there, and we're waiting for the judge to come on, and we're having a settlement conference. We had an autistic gentleman who his routine would have been disturbed by going over there, and the judge was able to, you know, allow us to have a Zoom conference.
That's great.
It's just like we're right in the judge's office, in the judge's chambers.
Yeah.
We took testimony, took witnesses, the judge ruled from the bench, and it's a much more expedient, cost-efficient way, you know, to handle some of those hearings depending. And now, obviously, sometimes there needs to be everybody in the courtroom to argue a case and things like that, but it's been a wonderful tool that is also expanded to meeting with clients and signing clients up, you know, virtually, getting medical records, all the things we need to begin the case. And I'd love to meet the clients, but again, sometimes the circumstances to where we cannot meet them in person because there's a time limit demand on what we need to do at the very outset of the case. So sadly, one good thing from COVID anyway was everybody getting a little more technologically savvy. Now William, he's our computer guy at the office, so he's doing all that.
Yeah, that's scary to think about.
You know, he speaks Spanish, so he's often on with, you know, a lot of people who don't speak as good English. So sometimes doesn't mean they're technically, you know, not savvy, but sometimes, you know, he can converse with them that way as well.
One of the other times we tend to be meeting with people via Zoom is venue. Okay, venue is proper either where a defendant resides or where an accident occurs. And what happens a lot of times is someone's driving through the state of Alabama, but they may live in Maryland or Washington or Texas. And they're going to need a lawyer in Alabama where that accident occurred. And so those folks now are much easier to get a hold of, to meet with, to speak to, than the way we used to do it of going and meeting with people and things like that. Although, like Will said, we still do that as well.
Yeah. We've got callers waiting. Ashley's on the line with a question from Huntsville. Hi, Ashley. Thanks for calling. What's your question tonight?
Hi, I was wondering, I was recently in a car wreck and I was hit by a drunk driver.
Okay.
But I was on the phone and I had my phone in my hand. So I was wondering, like, what is, you know, my liability or what is my responsibility in that car wreck?
Yeah.
William, we had a good question. There was a local ordinance was passed about that. Tell us a little bit about that.
Yeah, so it actually kicks into effect in January, but that local ordinance passed by the Huntsville City Council is a play off of the law that the state recently passed. And what the state passed, the state of Alabama, is that if your cell phone is in your hand, it is a secondary charge. And so what that means is the officer or state trooper can't pull you over for seeing you with the phone in your hand, but if he pulls you over for speeding or for something else, then he could also write you a ticket for having your phone in your hand. Now, with regards to the ordinance passed by Huntsville City, it's going to be a primary charge. So if they see you with that phone in your hand, they can pull you over and issue a citation off of that. But I don't think that's going to be the big thing here, Will.
Yeah, actually, what happened in the wreck?
So drunk driver hits her. just the fact that she's on the phone, that's not her fault. Right. It doesn't seem to be the cause of the accident.
It has to cause or contribute. Let's say the drunk driver hit her, ran a red light, whatever, and she had to be holding her phone. She's violation of that ordinance. Is that germane in the case? It may be, it may not. Again, they would have to show that was approximate cause of the wreck. For example, if you're drunk on the job and a wrecking ball falls on your head, the drunkenness didn't cause that. Let's just stand where you're not supposed to stand, you know?
Yeah.
And so you got to show that that is a viable defense and you were contributory negligent, like we talked about earlier. Now, on the drunk driver, now that gives rise to, usually if it's just an accident or it's just negligence, there is compensatory damages, medical bills, pain and suffering, and trying to get you back in this position you were before. Now, if there is alcohol or drugs involved, oftentimes punitive damages are something that we ask for to not only punish the defendant for his or her conduct, but to put everybody in this community on notice that this type of behavior is going to be punished and hopefully preclude that type of conduct in the future. And so just because you had your phone in the hand, Ashley, you know, that's not good, but that doesn't decide the particular case at hand. And I don't think that would bar you from recovery.
Let's change the facts of the case then. Let's imagine that the person who hit her was on the phone, or she thinks they were on the phone, they weren't paying good attention. How accurate, we see movies and things where they're able to track that phone and exactly what, were you on the phone, where were you, how fast was the phone moving. Is it really that accurate now? Are you seeing discovery, are you able to get that kind of evidence in with that kind of accuracy? Tracking the phone.
In most cases, we're getting that stuff in, and we're actually getting experts to come in to testify what was going on the phone, what app was open, what was the longitude and latitude at the time of the wreck. And oftentimes, William, let's say they said the wreck happened at noon, but it really happened, however the facts fall. Yeah. Sometimes that's important, sometimes it's not. But all of a sudden, when your phone stops moving, you know that's when the wreck happened. And you know, William, in the past we've had difficulty obtaining this. We have to put the carrier on notice that we want the content of what's going on through. How do we get that stuff?
It has to be subpoenaed, and that's going to, you know, produce this raw data, right? We're not getting a mirror of the phone. So that's where the expert, as Will said, comes into play to interpret that data and get it down. But, you know, the important thing for folks to remember out there is 3.5 seconds is the average amount of time it takes to send a text. If you're driving 60 miles per hour, you know, that's 100 yards. You've driven the length of a football field without looking at the road. So please, please, please do not text and drive.
Be careful.
And holidays are coming up, everybody's on the road, eggnog's flowing, things are getting, you know, be careful and do what you can to keep yourself safe.
We're going to take a break. Be right back. If you didn't get your questions answered tonight, here's how to get in touch with Will League and William Meservey with Timberlake and League. They are personal injury attorneys out of Huntsville. So anything from car accidents to medical mistakes. 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And our very own Sharon Dovey, family law attorney, child custody and divorce, 539-7337. SharonFamilyLaw.com. And Sharon, your stuff is all judge, no jury with the family stuff?
Yes, always judge, no jury. Can you imagine a jury with a family law or divorce case? Yes. And you guys are both. Sometimes judge, sometimes jury.
That's right.
Yeah.
That's right.
Thanks for all your questions, and everybody stay safe.